I wanted to know how people whose legal status was uncertain, who had no fixed place before the Constitution, how they might have gone about creating a sense of belonging in this country. And because oftentimes as historians we work a long time before a book actually gets between the covers, I should say I had no idea how important this topic would be here in 2018. So I'm deeply grateful to the museum for pairing me with such important partners and such an important discussion here in Richmond. It really is more than I think I ever hoped for in the work. I think one way we might tell the story of birthright citizenship and the 14th Amendment would be through the acts of highly placed lawmakers, judges, congresspeople. This is often the story we know. But what I want to do today is tell, I think, a less well-known chapter in that story, one that centers African-American activists, looks out nearly 4 decades before the 14th Amendment and 1868 to understand how it was that African Americans, in a sense, bequeathed to us this regime of birthright citizenship that still shapes our nation today. A bit of a scene. It's January 1869 in Washington, D.C. It's very cold. But the delegates to the National Convention of Colored Citizens have come together in Washington, D.C. This is a meeting of men and some women. They've come to discuss the issues of the day in the wake of birthright citizenship and the 14th Amendment. And they assign a committee to travel across town to call on Congress and to talk with members of the legislature about their concerns. They are foremost concerned about the vote. The 14th Amendment has sort of provided for the vote, but not in a very robust way. And they make their way across town and talk with the members of the House Judiciary Committee about their aspirations, about what they think birthright citizenship should mean, what sort of rights should be associated with this new status that they are enjoying. And the 14th Amendment, of course, is new in this moment. It's not even a year old, and so they are really testing, they are really trying out, they are really promoting and trying to shape the way that lawmakers will think about and act on the 14th Amendment going forward. This is really citizenship, right, in action, right? People showing up at the offices of their representatives, petitioning, in essence, for their notion of what they think their rights should be. So the 14th Amendment is new in 1869 when these men visit Congress, but the questions that the 14th Amendment tries to answer are old questions, questions that this community and others like it have been asking for a long time. Since the 1820s, black activists, along with legislators, along with courts, along with political commentators, have all puzzled over what the status of former slaves might be. They know a few things. There's no color line in the U.S. Constitution of 1787, but there's also no definition of who is a citizen in that document. And so my story today is partly about those decades and about how folks go about trying to make a way and trying to craft belonging when there is a big question about whether or not they do. One of the first debates happens in 1820, a long ways off from 1868, the 14th Amendment. Missouri is being admitted to the Union as a new state. And while there's a lot of consternation, once Missouri is going to be admitted, it's going to be admitted as a slave state, it still has to present its constitution to the Congress for approval. And in doing so, what the Congress observes is that Missouri has included a clause that, in essence, bars flat out the entry of free people of color, bars the entry of former slaves into the new state. And Congress takes a look at this and a debate erupts, because on the one hand, there are those who say this is a violation of the equal protection of the laws that are guaranteed to all citizens in the Constitution, the privileges and immunities of citizenship, as it's put. And there are others who say, well, perhaps it is as a general matter, but Black Americans are not citizens, and so indeed they don't enjoy this protection. And the debate goes on for some days, and it evidences to us the ways in which even in 1820 and 21, this question, this puzzle about free African Americans is a truly vexed one that is engendering, really for the first time in US history, hard thinking about who is a citizen and under what terms. What does Congress do? Well, probably in 2018 it won't surprise us so much. They can't figure it out, and they can't agree. And so in the end, they say to the state of Missouri, well, all right, you can keep this clause, and please don't violate the rights of citizens. Gosh, is that ambiguous enough for you? But it's an important moment because it really is a signal of the way in which this debate is going to unfold over time, which is to say, at each turn, as lawmakers and courts attempt to take a hold of this question, to settle the status of former slaves, they fumble, they punt, and they otherwise manage to leave this growing community of free people in the United States, North and South, in a kind of constitutional limbo for a very long time. African Americans, we begin to hear their voices in earnest by 1827 with the publication of the first Black newspaper in the United States, Freedom's Journal, which is published in New York City. And Freedom's Journal has a lot to say on many questions, as you can imagine, slavery being first and foremost among them. But what surprised me when I read Freedom's Journal was how much these editors and the correspondents to the paper were also thinking about the Constitution, about citizenship, about law, and belonging. And so here we have in the newspaper the first public forum for African American debate and deliberation. We have a kind of primer where African Americans are learning the terms of the Constitution and how they have been interpreted over time. And so it's a really important moment for us. What are they so vexed about? Why citizenship? Why is it that they are reading the Constitution so carefully? Why is it that they are using the very scant pages of this newspaper, expending ink and paper on this question? Well, they are facing two important companion problems, and they are problems. The first is the emergence of what we call the colonization movement. This ring, so I see some nods. Right? The colonization movement has a long history, subscribed to and in fact created by some of the most distinguished members of the founding generation. But by the 18-teens, colonization is now incorporated and organized to do what? To encourage, to promote, cajole, to coerce former slaves to leave the United States. Colonizationists believe that slavery will end eventually, but what they are sure about as well is that there is no future in an interracial democracy. There is no future for African Americans in the body politic. And so colonizations commission West African territories like Liberia. They promote movement to Canada and the Caribbean. They outfit ships. They provide incentives. And they gently, and in some cases not so gently, attempt to persuade former slaves to, in essence, self-deport. right? To leave the place of their birth, to abandon their claims to citizenship and to rights, and to go elsewhere where their prospects might be more promising. So this is one problem, and it is an important one and a powerful one. African Americans watch as Native people are removed by the 1830s from the Southwest, and they think, perhaps that's our future. Right? That's the goal of colonization. In addition to colonization, the other pressure they feel is in what we call today black laws. So here, these are state laws that over time increasingly regulate the day-to-day lives of former slaves. Where you can work, what kind of goods you can sell, when you can gather in a public assembly and under what sort of supervision, when you can travel, when you can return. Increasingly, day-to-day life through state legislation is being regulated, supervised, controlled, making people vulnerable to arrest, to punishment, even to re-enslavement by way of black laws. So these two pressures lead African Americans to think hard about how it is they're going to resist. And citizenship is, they hope, the answer. They experiment with ideas through something we call today the colored convention movement. Colored is their word in this period. And these are a series of local and state and even national meetings, though they don't extend all the way into the South in this period, but aspiring to be national meetings in which Black Americans are coming together periodically and discussing the issues of the day. Citizenship is on their agenda, and they are thinking hard, reading that Constitution. Anybody remember that place in the Constitution that provides for a natural-born citizen? Yeah, Professor. Oh, shoot, we've got a ringer in the crowd. Okay. Tell us where it is.
Presidential election, or people who are qualified to be president.
Exactly. Right? The president, they read in the Constitution, has to be a natural-born citizen. You all remember the Obama years. This was the birthright controversy, right? So they say, well, okay, if the president is a natural-born citizen, there must be such a thing, right? There's such a category, there's such a creature, and aren't we natural-born citizens, right? We're born here, just like men who become elected to the presidency. There's no color bar in the Constitution when it comes to natural-born citizens. And so you see the way in which they begin to work. They talk about military service. Among them are veterans of the American Revolution, the War of 1812. They talk about labor, of course, much of it over time unrequited labor. And all of this they experiment with, they debate, and ultimately they settle on birthright as what seems to be the sure, the unassailable, the most powerful argument they can make when it comes to citizenship. By the 1850s, this is a debate that takes on a really strident tone. I'm going to quote just a bit from Martin Delaney, who in 1852 publishes the first of his 12 books, called The Condition, Elevation, Emigration, and Destiny of the Colored People of the United States. Delaney writes, "We are Americans having a birthright citizenship." And this really becomes the refrain by the 1850s. Now there's an irony here, because Delaney publishes this book on the eve of his plans to emigrate or to leave the United States, right? There's a lament in this claim by the 1850s because Delaney does not see a future for African Americans. As persuaded as he and his compatriots are that they are citizens of the United States, they see no future, certainly not a bright one for themselves. And he's not alone in concluding that perhaps the land of their birth is not the future for African Americans. But many others are eking out a kind of semblance of rights in this period. Now, I got started on this work because I was interested in what today is a notorious U.S. Supreme Court decision, Dred Scott versus Sanford. I get a couple of nods, right? Dred Scott is a case that we know well from 1857. Scott himself was an enslaved man living in Missouri who claimed his freedom based upon having once lived in free territory in Illinois and in the Wisconsin territory. But when he finally, over the course of nearly 11 years, 12 years, reaches the end of his quest, he fails in his freedom, and what he hears from the U.S. Supreme Court is that not only is he going to remain a slave, but he's told by the U.S. Supreme Court that he has no right to bring a suit in federal court because the court's jurisdiction is limited to citizens of the United States, and he, as a slave, but in fact no black person, the Supreme Court says in 1857, can be a citizen of the United States. This is the story we know best. But part of what my research unearthed was a sort of countertale to this in the state of Maryland, where in 1858, the year after Dred Scott, a free African-American man named Samuel Jackson brings a lawsuit in his local courthouse in Dorchester County. Jackson is aggrieved because his family has been, in essence, kidnapped. His wife and 5 children have been taken from him, are being held by a neighbor, and he goes into his local courthouse to claim their freedom, to sue his neighbor for trespass. And he wins in Dorchester County. And he even wins a fine of $750, which is quite a sum in 1858. Well, his opponent appeals to the High Court in Maryland, and I should say his opponent is also a free man of color. And so his argument may strike you as odd, but also familiar. When they get to the Court of Appeals, Jackson's opponent says, well, A, I did nothing wrong, and I certainly don't want to pay this fine. But furthermore, Samuel Jackson has no right to bring a lawsuit against me, because in Maryland, we should adopt the rule of Dred Scott that says no free person of color has the right to sue in our courts. Free people of color should be banned. Now, it's an odd argument, because he's a man of color making this argument, right? Well, litigation is like that, folks, I can tell you. We make all kinds of arguments, a little bit with our tongue in our cheek, but he thinks it's a winner, and it's going to save him that $750 fine, right, that's looming. But the Maryland Court of Appeals says no, no thank you. Why? Well, it's complicated because this is not a racial egalitarian moment. These are not budding radical Republicans who are going to remake the racial order. These are not even particularly anti-slavery thinkers on the High Court in Maryland in 1858, but they are practical men. They are practical men. And they look out across their state. They observe a state with somewhere between 75,000 and 80,000 free people of color. And the court says, hold on a minute. These are workers. These are laborers. These are part of the lifeblood of our state. We can't easily or blithely dispense with them. And if we exclude them from the courthouse, in essence, what we do is create tens of thousands of outlaws in our very midst. How do we expect to maintain a social order when we bar people from the courthouse, that place where they should bring their disputes in an orderly, reasoned way? And Jackson wins. But freedom didn't guarantee citizenship. It didn't guarantee rights. And the 13th Amendment is a pretty bare bones provision of abolition. It is powerful, but it was limited, and self-consciously so. And so here, by 1865, African Americans are still working on this question of citizenship, but it's a new sort of moment, isn't it? There seems to be a new set of possibilities. And the first sign of that comes even before the 13th Amendment in 1862, when the Attorney General, Edward Bates, is asked to give an opinion. Are free men of color citizens of the United States such that they can pilot ships along the coastal waters of the nation? It's an old question, it turns out, that's been asked of nearly every Attorney General of the United States in the 19th century. But Bates gives a new answer to that question, which is yes, free men of color are citizens of the United States such that they can pilot ships. And African Americans begin to seize on this. It's the first time in which their deliberations and their conventions and in their newspapers is now in concert with the federal government. Now seems to be compatible with what's happening in Washington. John Mercer Langston, who has been a lawyer, an African-American lawyer in Ohio, is now in Washington and convenes at the 1864 Convention of Colored Men that year. And he invokes Bates's decision, right? He says, right, federal government, you're finally figuring it out, right? You're finally coming to see things our way. We are citizens. And this becomes the refrain over these years. Demands are put to Congress, and we know that by 1866, the first of the Civil Rights Act will, in its first section, provide for the birthright citizenship that African Americans had long been calling for. They had discovered it, they had built it, they had nurtured it. Even after Dred Scott, right, they had kept it going such that by the Civil War, they're able to serve it up and make it available to officials in Washington who pick it up and run with it. Lawmakers are catching up with their ideas. The 14th Amendment is ratified in 1868, and it aims to settle many questions. Its first section makes all persons born in the United States citizens of the United States, with an important exception that I hope we'll perhaps talk about in the general discussion, except those persons not subject to the jurisdiction of the United States. It's an important exception that is getting a new life today. In the 19th century, this is a provision that's intended to apply first to the children of foreign diplomats. Those children, though born in the United States, are not automatically birthright citizens. And it is not intended to apply to Native Americans, because Native Americans in this period are still retaining the sovereignty of their independent nations. Native people who live within those nations are citizens or subjects of their own nations, not of the United States. And so this is a preservation of Native American autonomy in 1868. But everyone else born in the United States is a citizen of the United States, entitled to the privileges of communities of citizenship, life, liberty, or property, and the equal protection of the laws. These are ideas that we still today are grappling with. So the story I've tried to tell is one about a long story about the 14th Amendment, the way in which the ideas that get enshrined in statutes and in constitutional amendments oftentimes have their origins in the day-to-day sustained and oftentimes bleak activism of people who have the greatest stake of all in these sorts of changes. African Americans adopt birthright citizenship when no one much is thinking about citizenship at all in the United States. It's sort of a non-question for native-born white people. It is assumed. But they turned it into a question, into a puzzle, into a problem, and sustain that in their everyday lives, as Samuel Jackson does in the Maryland courts, but also in this critical moment of the Civil War. At that 1869 convention that I started with, this is a delegation of men who go out to petition government. I have to tell you something about them. At their convention, they had faced a dilemma. There was a woman who presented herself, having been sent from her delegation in Pennsylvania, Helen Johnson, and she asserted that she would take her seat like all the other delegates at this African American convention just after the 14th Amendment. Well, there's a debate there too. which is to tell you that the men in this story are thinking hard and are being challenged about their ideas and the parameters of citizenship. How do women fit in? They seat Helen Johnson, and she participates fully in this convention. But when they go across town to Congress and they make the demand for voting rights, they do not include a demand for the rights of women as well. So we are at a juncture in a longer story, and an important story about the evolution of American citizenship, and I think that that's the last thing I want to leave you with, is that if I have an insight that comes from this work, I have lots of them. I could stay all night, but I want to get to our discussion. And what I want to leave you with is the sense, right, that citizenship has always been a vexed, contested, and difficult category. There's really no period in our history when citizenship was a fixed or settled or clear question. And I might even say to you that what democracy demands is that there are always people knocking at the door, asking the question, pushing on us as a collective to think and rethink what it means to belong and by what terms. This story about African Americans who live for many, many decades in legal limbo, who live with no clarity and still have the courage to build families, vocations, businesses, communities, churches, political organizations, even in the absence of that clarity, I think is both an inspiration for us, perhaps, in 2018, but also a cautionary tale. Because even as they did all that, as a nation, as a collective, we were willing to let them do that under the terrible cloud of uncertainty, under that threat of removal, under the strictures of the black laws, with really no promise, despite all they had contributed to the nation. So there is a lot of promise in this moment of the 14th Amendment, but of course it is not the end of the story, because as it persists today, and for some of us, I am someone born under the privileges of the 14th Amendment and Birthright citizen. I'm born in St. Clair's Hospital on the west side of Manhattan in 1958, and I am a Birthright citizen. But it's not enough, is it, in 2018, birthright citizenship? And if former slaves, as they wanted many things, civil rights and political rights, part of what they aspired to was autonomy for their families, right? The integrity of their families. What citizenship meant was, for the first time, that people whose lives had been subject to the vagaries of politics and owners and many other things were going to have control over their families. That, to me, seems like a value worth holding on to as we think about the lessons from this story for today. So I think I'll stop there and just say thanks very much for listening.